Oh, hello, everybody. That's what happens when you set a video on loop and then forget to take off the loop. Welcome in, everybody, to the Transcript. I am JT, and we are continuing on tonight with Sarah Boone's letters. We just so happen to make it into 2024, this year, the year of the trial, as nobody's saying. And, there's been some news as of late, so, I would be remiss if I didn't give you a little update into what's going on with the person who wrote the letters that we are reading. So let's do that right now, shall we? A Florida judge refused to delay Sarah Boone's murder trial, saying it is the defendant's own fault that her attorney has only a month to prepare. Boone was smiling as she appeared in court on Tuesday for a hearing alongside her new attorney. The ninth to represent her on charges that she killed her boyfriend, Jorge Torres Jr. Torres was found dead, zipped inside of a suitcase after a night of drinking. James Owens, who stepped in to represent Boone, asked Judge Michael Kranick to delay the murder trial until the end of this year or the beginning of 2025, whichever comes first, right? Citing a need to hire expert witnesses to pursue a battered spouse defense. Owens joined the case on August 30th because Boone struggled to represent herself after Judge Kranick ruled she had forfeited her right to an attorney. Owens said that he plans to hire 2 forensic psychologists to serve as experts to bolster a battered spouse defense, which, by the way, news came out that the state is trying to throw that defense out the window. But the deadline to file a notice for that defense is September 7th. Owens said he has been unable to access digital evidence or go through the discovery that now sits in boxes with Boone at the Orange County Jail. So she now has the boxes that she said she never had, and because she has the boxes, he can't go through it now. Woo! Among the experts Owens said he wants to hire is Dr. Michael Brannon, who recently testified after diagnosing Marsha Thompson with battered wife syndrome. In July, a jury found Thompson not guilty of first-degree murder in the shooting death of her husband. Kranick refused to continue the trial, noting that the case had already been pending for 4 years, 6 months, and 4 days. Looks like he's counting now, too. It's not just Sarah Boone. Also, I think that was kind of like a little dig. He admonished that Owens was fully aware of the trial dates and deadlines when he stepped into the case, and that Boone, quote, only has herself to blame for her previous attorney's withdrawals. Speaking outside of... This is weird, y'all. This, to me, is super weird. So, and the weirdest part is at the end. Speaking outside of court after the hearing, Owens said that he had unsuccessfully attempted to negotiate a plea deal for Boone, but will move forward with the case despite being unable to secure a continuance. Quote, I'm going to have some help, Owens acknowledged. I'm trying to assemble a team right now, Avengers Assemble. Owens also noted that he was not working pro bono on the case, telling the cameras, Sarah owes me. What does that mean? Sarah owes me. Ugh. Motions hearing September 26th. Her trial scheduled to start on October 7th. So a lot going on there, huh? A lot of crazy things happening. I did want to kind of show you a little bit about our good buddy James Owens. James Owens, attorney at law. He works out of Milton, Florida. So just to give you an idea, ignore the color choices. I would not choose that. But since we are a reading show, his first thing that he writes here is, build a solid defense. Meet with James Owens, attorney at law, to discuss your case. If you're facing criminal charges, every second counts. Don't worry, Sarah she'll count them. While the prosecution's gathering evidence against you, you'll need an experienced lawyer who can defend your rights. Don't delay. Contact James Owens right away to hire a skilled criminal defense lawyer. He'll stand by your side and fight tirelessly for the best possible outcome in court. As a top Florida trial lawyer since 1986, James Owens has handled countless cases from simple misdemeanors to serious felonies. He'll help you understand your rights and explore every legal option. Why should you choose James Owen? A guilty conviction for criminal charges can potentially ruin your future. I'm pretty sure a guilty conviction for criminal charges will. You need to know that your criminal defense lawyer is looking out for your best interests at all times. James Owens provides tremendous value to his clients with over 35 years of experience in the courtroom, knowledge of both sides of the law as a former criminal prosecutor, convenient virtual consultations and text availability 24/7. You probably shouldn't have put that on there because Sarah likes cell phone numbers. Yes, agreed. Also correct. Personalized legal strategies with proven results. That's really weird brag. That's a really weird flex. Like, I hope it's personalized, but I suppose there are lawyers out there that's just like, we're going to do this. I do it every time. Attorney Owens has taken over 100 jury trials to a verdict. He'll be your strongest advocate in court and offer unrelenting representation on your behalf. Question for you, my viewers. If he's got over 35 years of experience, but he's taken only over 100 jury trials to verdict, is that a good stat? I mean, does that mean that the majority of them just go to pleas? I don't even know if that's a good stat or not. It doesn't sound like a lot, but I really don't know. No idea. But if that wasn't enough, he's got his About Me. They're adorable. That's for sure. So prosecutor in Pensacola, 1986 to 1989, elected public defender, First Judicial Circuit of Florida, 2009 to 2012, private practice, criminal defense, 20 plus years, handled over 100 jury trials to verdict, handled cases in Escambia, Santa Rosa, and Okaloosa. See, this is why you got the Florida man. You got to be drunk to say these names. Okaloosa County, Florida. So for a moment you thought, no, ma'am. Absolutely not. We've long ago, one of the first lessons I ever learned streaming was no phones, no call-ins. I love you all, but you can't control a call-in, and I certainly don't have. I mean, I do have a wonderful behind-the-scenes group of mods and producers and stuff, but that's a lot to put on somebody to take calls and basically filter them before they get over here. It's a whole thing. Not gonna do it. Wouldn't be prudent. Not gonna do it. Won't do it. I have too much hope for our channel. So that's James Owens. Now, here's the thing. How did she get James Owens? Well, let me show you. She decided to draw up an advertisement. And to be honest with you, kind of reminds me of serial killer. So here you go. And let's read it, shall we? Inmate seeks attorney. Looking for a prosperous challenge? Ready for your close-up on national television. Are you zealous with a side of keen? Well, that's cute, see? I wonder if that was her Tinder profile. Show the world who you are with your original creativity, extraordinary expertise, and confident ingenuity. Qualifications must include being trustworthy, honest, passion-driven, open-minded, exceptional problem-solving skills, client inclusion at all times, team orientation, collaboration, extreme efficiency in listening, communicating, understanding, dedication to success, possessing a winning mindset, capability of excellence in representation, committed, maintaining faith in the client and case with the ability to think differently and overcome all circumstances. In other words, if you can't overcome one of them, I'm firing you. Epic opportunity awaits. Sarah Boone, Number 2000563, Orange County Corrections Department. Invest in the oppressed. Believe. Side effects include diarrhea, constipation, and dizziness. Wow, Sarah. Just wow. You know, from the, I mean, I really can't give her a hard time for being desperate. She's in a murder trial. She forgot must be nice to me. Correct. And I would imagine he has seen the video. And it sounded like from that news article that he actually tried to get a plea bargain, a plea deal for her. But since that was unsuccessfully attempted, because I'm sure Sarah said no, they're moving forward. So quite interesting, quite an interesting situation. We'll see how it goes. But you know, can you? I guess they could appeal for not having enough time to mount a defense, but the judge already ruled on that, so probably not. But that's probably true too. Man, what a life. Well, like I said, we moved into 2024. Some of these letters are doozies. I will say this, you know, if we do get through these tonight, next week will be something different, obviously, because we won't have any more of these. Looking at the possibility, oh, geez, I just blanked. Why did I blank? 1 second. 1 second. Nope, that's not it. I'm getting all my names mixed up. Oh, shoot. It's another big case. Why am I blanking? Oh my gosh. You know what? Somebody's going to remind me. Somebody will say something and it'll hit me, I'm sure. Oh, good gosh. This hurts actually a lot. Man, lols. That's the first lol of the show. Awesome. I'm good at this. I can't remember, but it's a document for a third party defense that I think the third party defense was thrown out. I am trying to remember. It had a name too. That's why I can't remember the person. It's gonna kill me. I'm sorry, everybody. Delphi. Good God, that hurt. Delphi. So possibly reading that document. Which is much different than these. So just strap in for that one. But here we go. All right. So this is January 19th, 2024. And this is to Judge Kranick. Thank you, Richard Allen. Yes. And that's what I've heard. Producer Lama's read through that document, and she has said that it is fascinating, very difficult in terms of content. But, you know, that's something that might be interesting to everybody. So that'll be fascinating to read through. All right. Honorable Judge Kranick. Finally, a new judge. It's strange how the Lord works. As I was in the process of trying to disqualify Wooten after being my judge 4 years, and me still incarcerated with nothing to show other than 7 different attorneys. Not by choice. News clips of me walking in and out of the courtroom and everything relative to my case permitted to be slathered on the global internet, and in which I have not seen myself. I felt he was the ticket holder to my overly hyped, illicitly distributed, misconstrued criminal case, And great reason I'm still here. Again, ongoing. 4 years and 7 attorneys later, not by choice. See later dated 6/29/23 on clerk's website. While still waiting to properly elucidate the court, public, and the world, and after whatever the dysfunction was in the attendance part of my most recent PTC status hearing, which I am trying to ensure my automatic attendance futuristically. We're back. Futuristically. Yeah. Please see my draft motion included. I am still trying to have my attorney submit on my behalf. I wanted to bring to your judicial attention the following information, so you and the world are aware it is not I who am ever delaying trial, as Wooten inappropriately accused me of doing in a past hearing. Especially now, you have mandated a trial date to be had in May, with no further continuances, leaving less than 4 months to put together and complete what should and could have been done already. What happened in all the 4 years prior? Please see all my correspondence online. To date, Winston E. Hobson has been my court-appointed attorney for 133 days and counting. To date, Mr. Hobson has only met with me 1 time for a total of 3 hours on November 7th, 2023. Here's the thing. She really should have gotten a job like doing the whole, like, here's the alphabet, let's count to 10 on like Sesame Street. To date, no phone calls have been received by Mr. Hobson, as his phone does not work properly for further, immediate, much-needed communication to be made between client and attorney. To date, I have mailed 5 letters to Mr. Hobson trying to communicate my urgent need to speak to him. To date, I sent 1 letter to the investigator in my case to contact Hobson to contact me and see if he can assist in correcting the phone problem. Also to inquire when anyone is coming. To date, I feel I am... To date is gonna be the date that he's gonna get back to you. Gotta fix his cell phone because he never wants to hear from you. Okay. To date, I feel I am not being included or heard or cared about in my case again from the continued miscommunication again with Mr. Hobson, and time-consuming, undiscussed entries are being made on my behalf. The continuance I did not know about, the waiver of appearance I did not know about, along with other documents. And I am never sent copies of anything filed, so I know. I keep trying to tell him about with no response, furthering the already massive dysfunction in my 4-year case. By the way, as I read through this, I just want to say, R.I.P. James Earl Jones. I literally would have paid good money to hear him voice over these. I was hoping in the PTC status hearing on Tuesday, 1/16/24, I could at least play catch up in the courtroom. You were that student. You were that student. For 5 minutes, so many of my attorneys have done prior, including Mr. Hobson, in the 1 court date I've had for a continuance of a continuance, 10/30/23, to express and emphasize the need for him to communicate and schedule a second very overdue meeting. I still have not even heard from Mr. Hobson about our missed PTC status hearing. What's the status? To date, I, out of 100... Sorry, it's a 1. See, look, the 1 number she doesn't spell out afterwards, and I mess it up. Sarah, you missed a spot. To date, 1 out of 133 days and counting, attorney and his client have met. To date, 3 out of now 3,192 hours, attorney and client have discussed partial general case information. To date, I still have not seen my discovery. Your Honor, when is the next status hearing phase? Especially since we were not at the last PTC status hearing, and especially since I am trying to communicate with my attorney in more than one way to fully maximize and utilize the minute amount of time allotted before trial. My fair, appropriate, lawful trial? You stay classy, San Diego? Who put the question mark on the... She's got a question mark over her head. And on the teleprompter. She strikes me as that person who, like, didn't finish the homework, but then emails their instructor with, like, such a thought out fib that it just, like, double talks the instructor into being like, you can turn it in tomorrow. I still am wondering why, though, I've had to wait for 4 years for something to finally happen in my case. Ask Judge Wooten. I wonder also, was I the oldest case on his docket? Oh, don't call your age out like that, Sarah. It's okay. Either way, I'm still here, waiting patiently and very excited to get this highly anticipated show on the road. I await your overdue and very needed judicial direction, supervision, and intervention. Thank you in advance, Judge Kranick. Welcome. Welcome. Oh, welcome to the Thunderdome, bitch. Sincerely, Sarah Boone. Oh, this is... Hold on, wait a second. Is this a newie? Is this a new one? Or did we... we're going to read this. In the circuit... I just imagine this opening is like Law and Order. In the Circuit Court of the 9th Judicial Circuit in and for Orange County, Florida. State of Florida, plaintiff. V. Sarah Boone, defendant. Motion to be included in and allowed admittance to all defendants' pre-trial conferences and hearings. This is accurate. Two go in, one comes out. It's like tacos. Oh, that was inappropriate. My bad. I made myself laugh. Comes now, defendant Sarah Boone. Comes now, defendant Sarah Boone, by and through her undersigned attorney, Winston E. Hobson. What a name. Respectfully requests and conference. I lost all train because I was like, what is on the side here? And it says draft. No kidding. Oh, okay. Respectfully requests permittance to attend all my pre-trial conferences and hearings ongoing until the conclusion of my criminal case. Per FRCP Rule 3.22001, the following is stated to lawfully allow my inclusion, participation, and requested admittance. In case you didn't know, Judge, 1. The trial court may hold see? Didn't spell out again, one or more pre-trial conferences to consider such matters, as we will promote a fair and expeditious trial. The defendant must be present at any pre-trial conference, unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. In support, the defendant alleges as follows. These pre-trial conferences are for my personal individual criminal case. If professional YouTubers, no, semi-professional, news channels, court TV, etc. are given permission and allowed entry to the courtroom for viewing, and the judge also is allowing the conferences to be streamed live with all the court minutes uploaded to the internet and world, I, the defendant, should be included foremost. 2. I may not have regular, consistent updates or communication with my court-appointed attorney, and by attending all my PTCs and hearings, I will know current status, important dates, casework being completed, changes in parties, timeframes, expectations, all pertinent information I, the defendant, have a right to know, want, and need to regarding my case. All information is important, relative, and necessary to me. She's not wrong. She's not wrong. 3. I am not consistently included in the certificates of service and sent copies of any documents being filed in court regarding my case, as requested numerous times by the defendant in writing and... wait a second. And then she says the defendant. Okay. In writing and verbally in the courtroom, neither by the judge, the court, or my attorneys, By attending my pretrial conferences, I will know what documents have been filed, need to be, and will be for and in my case. Another way I can know what is going on in my case and being worked on. Number 4, in complete overall support. It is my right by law as an individual, defendant, and inmate to be included in any and all developments made in my case. It also is my right to finally achieve success in any and every aspect possible in my case. Okay, ma'am. Have you watched your video? By attending and being included in my pretrial conferences and hearings, said success can and will be accomplished fairly, faster, and properly. Wherefore art thou, Sarah Boone? Wherefore, the defendant, Sarah Boone, respectfully asks the Honorable Court to grant my motion to be included going forward to all defendants' pretrial conferences and hearings. By Sarah Boone. Oh, look, we got a certificate of service as well. I certify that an original of this document has been filed via U.S. mail with the clerk of the court of the Ninth Judicial Circuit, and that a copy of this document will be filed in the Florida e-portal to state attorney and all attorneys or other parties on court record on this 19th day of January 2024. Sarah Boone. What a letter. Now, hold on a second. Hold on. Hey, guys, we're not going to get through all of this. Oh, there's maps included. Okay. Well, we got one more week of this. Can you tell? I genuinely... It's not that I don't want to look into these ahead of time. It's that it's much better if I respond and react along with everybody else. You just get more genuine responses that way. I would absolutely read these ahead of time if I thought it would assist, but I don't think it does any good if I read them and then just think too much and get in my head. Yeah, I did. You're right. Oh, we'll get there. We will get there. Good gracious. Okay. So this was hand delivered June 7th, 2024. I don't know by who. I appreciate that she changed the font. Sarah Boone, Smart Communications, Orange County Department of Corrections, regular correspondence, legal correspondence. Now, wait a second. Oh, God, she's got an address for her regular correspondence and her legal correspondence. Clever. Just in case you forget, because you remember last time they forgot to scan both sides of the page, so she just wants you to remember. You see this? This is very much a very lazy signature. I think at this point, the clerk's just like, you know what, just have it. Just put it in there. All right. Map time. Here's the map. It's just like mail time. Here's the mail. It never fails. It makes me want to wag my tail. Honorable Judge Kranick. Ongoing 5 years. Why can't I use my constitutional rights? Am I the only one who cares about the ongoing violations of? Have a bond, ma'am. Have all my medical records. Have all my digital evidence and discovery. Have all my paperwork, notes, letters, pictures, everything of mine returned by former attorneys. Speak to my investigator. Have a complete download of my phone. Have you like that, wouldn't you? Have any of my witness lists. Give any insight, understanding, clarification, truths about my case, especially to my attorney. Be listened to by anyone, especially my attorney. Be respected for who I am truly, especially by my attorney, and not be disrespected for the mutated, malicious murderer all the world has falsely, incorrectly created and believes me to be. Ma'am, that's a non-starter. Be treated fairly, lawfully, and be protected by the justice system. Oh, justice system. Properly, rightfully, completely defend myself. If you've forgotten, it started out with, why can't I? see all and know the same as the world can and does, including my attorney, from all the phenomenal, non-permissive amount of my entire case being available online globally before my trial, and most important, before I have seen myself. Before I have seen... Oh. Like, you haven't seen yourself? Before I've seen myself. What doesn't anyone know already about my case? How about my side and everything about everything? Pretty sure it was your phone. Yeah, right? We all watched it. Be correctly understood that I am not the problem for reasons I am on malappointed. I am on malappointed by the... Hold on. Reasons I am on malappointed, I don't know, by the court attorney number 8. See my letter 7/21/23. Say what I want and should, but all the world can, and say it all wrong and warped. Why won't... Oh, geez, this is like a poem, y'all. This is like a beat poem. I mean, come on, right? It's not really beat poetry music, but whatever. Why won't my attorney give me an honest answer? Show me everything she says she has and finished reviewing for my case. But withholds from me after I ask repeatedly for and about. Give me an answer other than, I'm putting this to rest. That's not necessary, or I'm not having this conversation with you. Grant me access to anything I ask for in and about my case. Like the detectives in my case, stop putting words in my mouth. Tell me what's going on in my case. It's been well over 100 days. She has been my attorney, and I still do not know. Ongoing 5 years. Answer any of my questions. Ever ask me any questions? How can she supposedly know everything she needs to know from what she's been told, heard, read, seen? Reassure she's on my side, for me, not against. Why have I already been judged in the court of public opinion? How did that happen? Why have I been sentenced by anticipation and condemned before my predicted trial? Why does my attorney and all the world think my case is already over? Your Honor, during our first introduction at my last withdrawal of court-appointed attorney number 7, Hobson, you stated to me your uninvolvement with any of my letters I write. I said, not me. I am still going to write my letters as conduitly they are to the world where all my potential jurors are located, and this is the only way anyone, including yourself, knows the very necessary insight to my continued disadvantages, hindrances, impediments. Shift F7. I am still experiencing, on top of the new spurring my intentions to write. The race to the pulpit is unfair, and it is important to me that you are aware and understand what transpires when the news cameras are off, and we're all in between my status hearings. 2. As so many of the advantageous embezzlers, racketeers, mindless lemmings, and just altogether mean people, meanie faces, cuckoo heads, can use their freedom of speech, not knowing me in any way other than what's being said by all the other mean people and being said incredibly incorrectly. So can I. I too can do it. As the compelling, annoyed detectives in my case Capsule had the falsified documents, and Lowen wore his gun for me to see. I am sure you are familiar with, after watching all my plastered, highly misconstrued, over 30 plus million. That's a little I get a little high on the hill there for yourself there. 30 plus million views just on one site. I refuse to think that Sarah Boone has more views than... I'm just... me. Views just on one site, interviews, and in which they both repeatedly attempted to feed me their incorrect, incomplete, hypothesized Shift F7 opinion. by stating to me, everyone has their limits, at this seemingly endless point of perpetuality of nonsense and lawlessness still growing. And I very much want to advance to the next level. After ongoing 5 years now, a genuine concern limit has been reached. I get it. Why am I still not being included in my case? How much more of my case itself is being added hourly? Especially after this letter gets loose to the internet. You're welcome, Sarah. To the internet, increasing the mass infection and destruction of my hopes to have a fair trial. Anything fair. My side foremost, and wondering now if my attorney drank the punch like everyone else. Here's the thing. If she knows that her letters are being put out there and published, which of course they were, and she knew this, why don't you just write your side in your capital T truth and submit it? I don't get it. Like, put it all together, put it in a letter, and then it'll go out. And then people will know what you're saying. But you notice, I'm not doing that. All aforementioned reasons and so many more for this letter to be written, hoping to deter some of the unfair, one-sided finger-pointing of corruption and malpractice being directed at me only by those in the justice system who are trying to deflect the shame and shock from me fearlessly challenging the status quo. And it must be so because it's in my face on the computer at the same time on my boob tube television, brainwashed, ignorant followers of disbelief, conformity, and greed trying unsuccessfully to make my life by character assassination seem worse than theirs. Oh. Man, put her up against Eminem. She might have a chance. No, two, when anyone points their fingers, 1, it's impolite. And 2, 3 point back at you. How many tried it to see? Ha, 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 ha. Put the stone down, as there will be no casting of anything today. She all over the place today. Put the stone down, as there will be no casting of anything today, except maybe for the role of my part for all the pre-conclusioned documentaries and crystal ball real-life stories of true crime incorrectly formulated from everyone supposedly knowing me and judging who they think I am, what really happened, and is going to futuristically. Remember, 3 point back. Soothsaying is not a real job. TLDR, in the words of my attorney after I told her to Google me, she stated, there's a lot. To sum it up in the words of myself, the defendant, stated to my attorney after she stated that to me, when can I see? How much longer do I have to wait? Or how many attorneys must be withdrawn for me to be included in my case, and be included more than the world presently is? This is my case in every aspect. See all my aforementioned ongoing 5-year questions. I'm still waiting on for answers. Also, I wanted to make it known I walked out on my attorney in our last meeting due to her unwarranted, uninformative, unprofessional, shoddy attitude. Oh, snotty attitude. And her untruthful answers to my questions and beyond. What? Okay. Excuse me for the use of this. The, quote, retarded vicious circle, end quote, we enter every time we meet is a waste of time. And I'm saying that being in jail with supposed endless amounts of how she treats me is extremely prejudiced Wait. Yep. Hostile and unconcerned. She is very frustrating. 1. To balk or defeat in an endeavor. 2. To introduce feelings of insecurity, discouragement, or dissatisfaction in. And 3. To bring to nothing. So much I presented my solution in order to coexist with and work together in a hopeful, progressive, positive, appropriate manner. I added pretend judge to our interactions so she could calm down and ease up on her condescension, offensive demeanor, and obvious prejudgment. He thinks you're looking in a mirror instead, Sarah. She seems, like everyone else, not to remember I am innocent until adjudged otherwise. I really want to know if that... I don't think that is a damn word. Interesting. Who knew? Now I do. Thanks, Sarah. That's grammar from Sarah. She treats me as if I am not. After my introduction and explanation for, with pretend judge in the room on the phone, I am trying to help her understand how she is making herself extremely unwelcoming when in front of a real judge and in the courtroom is how she should treat me, her client, at all times. Sarah, stop being a Karen. I should not have to invent pretend judge in order to be, and am not at all wrong for wanting to be respected. No matter the outcome, I am innocent until adjudged otherwise. My attorney, everyone's, should be fair, unbiased, trustworthy, honest, supportive, informative, protective, automatically, and effortlessly. Shift F7. I should feel secure. You know what's really funny to me? At the very beginning, she said that the judge didn't have time for her letters and didn't involve himself in them. And yet here we have the longest thing that has been put together. She said, "Well, I'll make you read it." Ma'am, if they're not going to read, they're not going to read Scarlet Letter, sure as hell not going to read Crime and Punishment. Just going to toss that out there. I should feel secure, highly confident, proud in her representing my life. I do not, and have said to her many times regarding her monumental disbelief in me and my case, which I believe contributes greatly to her inimical attitude towards me. I am hoping by this letter she will pick up the sword of injustice and fight alongside, not against me, as so many unmotivated, overwhelmed, weak attorneys prior who bowed out ungracefully and crept away from the battlefield unsuccessfully. Starting to sound like the narrator of You're Tigger. My case equals bizarre, equals unknown, equals different, equals ignorance, equals misunderstood, equals unfair. This does not mean my case can't equal success, and in more than one way. Ma'am, we do not Boone math here. We do not Boone math. Absolutely, 100%. This is all about her. While everyone continues to ring their bells of malevolence, I am ringing mine of hope, honor, plausibility, boldness. Listen, I am not a murderer. The justice system should equals fair, faith, trust, respect. Innocent until and if adjudged otherwise. 3-point back. Sarah Boone. Confused cat meme. Yes, thank you. What? What? Confused cat meme? Confused cat meme. Oh, that one. The one where it's like, There's more. Oh, God. We need this. I don't know why I'm surprised. Ha! This is a perfect song for this because it's entitled When No One Cares. June 4th, 2024. Video visit, 12 minutes. In addition to my previous letter intended for hand delivery on 6/7/24 at my status hearing, today my attorney made a video visit to go over everything I've been asking her for, and have also sent to her personally in 2 letters. 5.5. All on the public video visitation box, where on both sides of me, less than 5 inches away from my visit, other inmates were having their visits also. Ma'am, you wanted something. You're in jail. You got it. Shush. Give a moose a muffin. I have explained to my attorney numerous times. I really want to give like the old narrator sound here for this. I've explained to my attorney numerous times, previously writing and verbally, that despite Muslim, I do not in any way feel comfortable having in-depth, private meetings, regardless of my entire criminal case, on the visitation box, where there is no privacy whatsoever, and held in an open bay dorm with more than 62 other interested, all-ears inmates. She walked in my office, showed up and said, I've got a problem. And I said, we don't do math here. We don't gas math here. We don't math. She said, no, not that kind of problem. I said, I don't care when 2 trains meet in the middle either. She said, looks like I'm out. I cannot fully participate, if at all, from the entire dorm, officer included, trying to participate also in my case. As always, my attorney did not listen or care after I repeatedly tried reminding her of my unsecure environment, barking at me. I can listen or not, still going over speaking and not at all allowing me to respond. After repeating to her, you'd already counted 30 words in that one sentence. Oh, really? Up here somewhere? She loves long sentences. She does. She loves them. Because, I don't know if you know this, but long sentences also equal intelligence. Yikes. Yeah. After repeating to her over and over and over, while she's beginning to speak louder and over me, still to please schedule an in-person meeting where all can be discussed further privately with no success. She wants a short sentence. Maybe she writes long sentences to get a short sentence. You tossed that one up in the air for me, so thank you. Discussed further privately with no success of being heard, I disconnected the visit telephonically. She uncooperatively. She is impossible. See previous letter, or ask her for a copy of the 2 I sent her. I was trying to remedy or lessen before sending this to you, Your Honor, and not having to include. Now it's a race to the pulpit. I gotta get to you before she does. She's touching me. She's touching me. I'll turn this car around. What's his name, Mo? My question, please. Who asks like that and still be able to call themselves professional? Who acts like that? The visitation box is primarily for family and friends to connect. And if a what? Ma'am? Friends to connect. And if I don't even know. If a something from an attorney, reminders, notices, quick questions, not high level. Not high-level confidential case information. What are we screaming about? She, like other former attorneys, who always blame their dysfunctions on me, said, "You don't like the answers I give you?" What answers? See pages 1, 2, and 3. I am not the problem, except that I want and should be treated fairly with respect, acting more professional than the paid. I've been doing this for over 40 years, professional. I deeply regret doing that. Do you think she had to clean up her cell after all the pea soup? Got it. I've been doing this for over 40 years. After so long, and in all the experience, common courtesy, customer service, and listening skills should have been acquired. All attorneys, do you remember why you even wanted to be one? Remind yourself. No one listens. And it works in everyone's favor but mine. That I am a murderer stuck in jail, so they can pin on me they're uninterested, unmotivated, hopeless. They're going to be. Leave me over her haughty attitude. I am not wrong for not thinking less of myself, because everyone else has and does. This present attorney foremost. The justice system expects me and other inmates, aka clients, to accept its subpar, nonchalant, hypocritical, next on the list attorneys. They keep aimlessly throwing darts for and malappointing, praying they don't withdraw. I have not fired any attorneys appointed in my case. From me expecting the highest equal standards possible for wanting the absolute best outcome in my preposterous mismanaged case. You could have stopped at preposterous. And representing myself is not an option, as both judges have now threatened me with for... Wait, hold on. She's getting... Oh, Sarah, you hypocrite. We knew this already. Why am I surprised? Threatened me with from being outspoken and intelligent in all my observations of the ongoing abuse. I am and have experience. I have no new experiences from it always being the same. Blame Boone. I refuse to be moved. In wanting respect, no matter who everyone thinks I am. Clarity, inclusion, honesty, and professionalism. She sure did. She sure did. And another great reason not to have my case meetings on the public visitation box is my personal confidential inmate information, such as my visitation lists 2020 to 2023, with names, etc. My interactions with inmates and officers. What I eat when, and my personal jail calls also being thrown online. For what? To hate me more? Or to try to get others to, because I don't eat breakfast, or because I know some Latin, have short hair, my penmanship is nice? Man. Come closer. Come closer. You're not that interesting. Sorry. I had to let her know. The equivalent of me going to the other desk. Or because I'm not getting fat and sleeping all day, but rather fully applying myself, fighting still, making everyone upset from not having to fabricate, mutate, splice, edit. The world apparently knows all. What's next? How many times I go to the bathroom, and what function I perform? Oh, I get it. I read that wrong. What's next? What's next, man? Like, how many times I go to the bathroom and what function I perform? I don't want to know. Really don't. I mean, however, I think we should change the phrase to I gotta go drop a boon. Anybody? Drop a boon? Just a thought. She didn't mention it first. It's true. Yeah, for real. For real. But she can't read from her letters, so fun times. That's it. We're changing it. Dropping a boon. If anybody ever asks, you know where you heard it from first. Listen, if Skibbity Ohio can make it into the lexicon, I think dropping a boon can too. No one knows anything, nor seems to want to, from being comfortable in their corruption and stirring to be on top with ratings, web hits, and money. Ma'am, you're not doing me any favors. Just saying, Sarah Boone. Get with it. My case details, if anyone forgot. And if you think about it, all that keeps getting plastered and plagiarized, posted, and poked fun at about me, it's all in my favor. Proving myself right about all the mindless lemmings, shut-ins, the justice system advantageously abusing and profiting from everything in my case. Before my trial and before I've seen. Oh, for sure. Oh, yeah. She was that one, and she was also the student who was like, I got a question, when the teacher said, all right before we go, any questions? For sure. Please be sure to read my attachment for FRCP Rule 3.220E, restricting disclosure. Am I the only one who thinks of these things? No, I can't. You're a troll. You know what, though? I'm going to let you have your time. Our mods can handle it. Dude, grow up. Grow up. You're not impacting anybody. You just look like a tool bag. Man, the juxtaposition between the music and me. Yep. When can I win? In anything. It's coming. I am not the problem. And if anyone were to slip on my slides and have to experience, tolerate, deal with any of what I have and am, would bravely be doing the same. Don't knock it till you try it. 3-point back. Race to the pulpit. Again. Always. Sarah Boone. Oh, don't you worry about it. I expect it by now. It's cliche at this point. Just cliche. Seriously. But you know what? At least they used their own name this time and didn't hide behind a billion other profiles. Here's the thing, y'all. When this stuff starts happening, you know you're making an impact. So here we go. West Florida Statutes Annotated Florida Rules of Criminal Procedure 3.220.6 Discovery. But wait, there's more. Oh, man. This didn't go well for the ShamWow guy. A. Notice of discovery. After the filing of the charging document, a defendant may elect to participate in the discovery process provided by these. Hold on. This music is not going to fly. There we go. Yeah. May elect to participate in the discovery process provided by these rules, including the taking of discovery depositions by filing with the court and serving on the prosecuting attorney a notice of discovery, which shall bind both the prosecution and defendant to all discovery procedures contained in these rules. B. Prosecutor's discovery obligation. 1. Within 15 days after service of the notice of discovery, the prosecutor shall serve a written discovery exhibit which shall disclose to the defendant and permit the defendant to inspect, copy, test, and photograph the following information and material within the state's possession or control. A list of the names and addresses of all persons known to the prosecutor to have information that may be relevant to any offense charged or any defense thereto, or to any similar fact, evidence to be presented at trial under Section 90.4042 Florida statutes. B, the statement of any person whose name is furnished in compliance with preceding subdivision. The term statement as used herein includes a written statement made by the person and signed or otherwise adopted or approved by the person, and also includes any statement of any kind or manner made by the person and written or recorded or summarized in any writing or recording. The term statement is specifically intended to include all police and investigative reports of any kind prepared for or in connection with the case, but shall not include the notes from which those reports are compiled. C. Any written or recorded statements and the substance of any oral statements made by the defendant, including a copy of any statements contained in police reports or report summaries, together with the name and address of each witness to the statements. B. D. Letters. Any written or recorded statements and the substance of any oral statements by a co-defendant. E. Those portions of recorded grand jury minutes that contain testimony of the defendant. F. Any tangible papers or objects that were obtained or belonged to the defendant. G. Whether the state has any material or information that has been provided by a confidential informant. H. Whether there has been any electronic surveillance, including wiretapping of the premises of the defendants or of conversations to which the defendant was a party, and any documents relating thereto. Could she not have just said, please see pages blank to blank? I. Whether there has been any search or seizure and any documents relating thereto. J. Reports or statements of experts made in connection with the particular case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons. K. Any tangible papers or objects that the prosecuting attorney intends to use in the hearing or trial and that were not obtained from or that did not belong to defendant. L. Any tangible paper, objects, or substances in the possession of law enforcement that could be tested for DNA. And M. Whether the state has any material or information that has been provided by an informant witness. Did she really continue this? Holy criminy. Alright, we're getting to it. Maybe. 2. If the court determines in camera that any police or investigative report contains irrelevant sensitive information interrelated with other crimes or criminal activities, and the disclosure of the contents of the police report may seriously impair law enforcement or jeopardize the investigation of those other crimes or activities, the court may prohibit or partially restrict the disclosure. 3. The court may prohibit the state from introducing into evidence any of the foregoing material not disclosed, so as to secure and maintain fairness in the just determination of the cause. 4. As soon as practicable. I'm pretty sure it's practical. As soon as whatever. After the filing of the charging document, the prosecutor shall disclose to the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant as any offense charged, regardless of whether the defendant has incurred reciprocal discovery obligations. D. Defendant's obligation. 1. If a defendant elects to participate in hey, we're learning today, right? Discovery. It's class with Sarah. Through filing the appropriate notice or by participating in any discovery process, including the taking of a discovery deposition, the following disclosures shall be made. A. Within 15 days after receipt by the defendant of the discovery exhibit furnished by the prosecutor pursuant to subdivision B1A of this rule, the defendant shall furnish to the prosecution a written list of the names and addresses of all witnesses whom the defendant expects to call as witnesses at the trial or hearing. When the prosecutor subpoenas a witness whose name has been furnished by the defendant, except for trial subpoenas, the rules applicable to the taking of depositions shall apply. B. Within 15 days after receipt of the prosecutor's discovery exhibit, the defendant shall serve a written discovery exhibit, which shall disclose to and permit the prosecutor to inspect, copy, test, and photograph the following information and material that is in the defendant's possession or control. I. The statement of any person listed in subdivision D1A other than of the defendant. 2. Reports or statements of experts that the defendant intends to use as a witness at a trial or hearing, made in connection with the particular case, including results of physical or mental examinations and of scientific tests, experiments, or comparisons. And 3, any tangible papers or objects that the defendant intends to use in the hearing or trial. 2, the prosecutor and the defendant shall perform their obligations under this rule in a manner mutually agreeable as ordered by the court. 3, the filing of a motion for protective order by the prosecutor will automatically stay the times provided for in this subdivision. If a protective order is granted, the defendant may, within 2 days thereafter, or at any time before the prosecutor furnishes the information or material that is subject of the motion for protective order, withdraw the defendant's notice of discovery and not be required to furnish reciprocal discovery. E. Are you guys having fun yet? E. Restricting disclosure. The court on its own initiative or on motion of counsel shall deny or partially restrict disclosures authorized by this rule if it finds there is substantial risk to any person or physical harm, intimidation, bribery, economic reprisals, or unnecessary annoyance or embarrassment resulting from the disclosure that outweighs any usefulness of the disclosure to either party. All I'm saying is this section seems like they would have used it in order to limit the disclosure of discovery. F, additional discovery. On a showing of materiality, the court may require such discovery to the parties as justice may require. H, sanctions. If I'm having a hard time with I's and ones tonight. If at any time during the course of the proceedings it is brought to the attention of the court that a party has failed to comply with the applicable discovery rule, the court may order the party to comply with the discovery or inspection of materials not previously disclosed or produced, grant a continuance, grant a mistrial, prohibit the party from calling a witness not disclosed, or introducing in evidence the material not disclosed, or enter such other order as it deems just under the circumstances. Are we done yet, Sarah? Are we done yet? All right, we're almost done. Let's see. We're gonna go to B. Not interpose for any improper use or purpose, such as to harass or to cause unnecessary delay or needless increase in cost of litigation. And C, not unreasonable or unduly burdensome or expensive, given the needs of the case and the importance of the issues at stake in the litigation. O, pretrial conference 1. The trial court may hold one or more pretrial conferences, PTCs, to consider such matters as will promote a fair and expeditious trial. Really? The defendant must be present at any pretrial conference unless the defendant's presence is waived in writing or on the record by the defendant or by the defendant's counsel with the defendant's consent. We've heard that a couple of times, and by that I mean in every letter. The court may set, and upon the request of any party, must set a discovery schedule, including a discovery cutoff date at the pretrial conference. Quote, that the individual shall have full protection in person and in property. I don't think he had a beer and he was sitting at home watching something else, because I highly doubt he read any of this. I only have water. I do deeply regret that. That the individual shall have full protection in person and in property is a principle as old as common law, but it has been found necessary from time to time to define anew the exact nature, excellence of such protection. Okay? Political, social, and economic changes entail the recognition of new rights, and the common law, in its eternal youth, grows to meet the demands of society. Is she calling herself society? Thus, in very early times, the law gave remedy only for physical interference with life and property, for trespasses viet amis. Then the right to life served only to protect the subject from battery in its various forms. Liberty meant freedom from restraint, and the right to property secured to the individual his lands and his cattle. Later, there came a recognition of man's spiritual nature, of his feelings, and his intellect. What the hell is she going to? Oh, got it. Gradually, the scope of these legal rights broadened, and now the right to life comes to mean the right to enjoy life, the right to be let alone. The right to liberty secures the exercise of extensive privileges, and the term property has grown to comprise every form of possession, intangible and tangible. Bouvier, Law Dictionary, 2012 edition. I like this one. The right to be left alone. The right to be let alone. All right. Hey, we're quoting different documents now, guys. American Declaration of Independence. We we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Florida Constitution, 2024. We, the people of the state of Florida, being grateful to Almighty God for our constitutional liberty, in order to secure its benefits, perfect our government, ensure domestic tranquility, maintain public order, and guarantee equal civil and political rights to all. That's funny. Do ordain and establish this Constitution. Oh my God. Y'all, we are being taken to law class. Right? You'll be back. Soon you'll see. You remember you belong to me. I'm Sarah Boone. I know it all. And all my attorneys, they rise but fall. Client, a person who relies on the professional services of another. The client of an attorney is the person or entity represented and advised by the attorney. Yeah. Da 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 da. A client relationship commences for an attorney with an agreement with the performance of service in reliance on a request for representation or with a statement of representation on which the client relies. Aw, thanks, Jasper and Mom. Everybody say hi to Jasper. Oh, you already are. Look at that. You beat me to it. All attorneys owe a client a duty of zealous representation balanced by the obligation to serve justice and act as an officer of the court. Here's the thing. A lot of this is very subjective. Zealous. I mean, I know what the definition of zealous is, but everybody's understanding of that is different. Attorneys also have an obligation to keep the confidence of a client at all times and to keep the client informed of all matters related to the client's interests, to inform the client of law related to the client's affairs, and to defer to the client's decisions, although the attorney has no obligation to the client to perform or refrain from any act contrary to the highest standards of professional responsibility and to the law. Oh, attorney-client privilege. She's got something. If only she had high expectations for her own behavior, she wouldn't have been stuck here. Attorney-client privilege. One of the oldest recognized privileges for honest, equitable, confidential communications intended to encourage open, full, and frank communication between attorneys and their clients, thereby promoting broader, confident correspondence in accordance to the appropriate observance of law and the administration of justice. Zealous advocacy. An attorney must represent each... Oh, well, see, she knew I was going to point that out, that it's subjective, right? So here we go. Jasper, did you just dab? Did you just... An attorney must represent each client to the fullest extent under the law and requires representation to the attorney's fullest abilities without violating the rules of professional responsibility. It requires not only presenting each argument required by a client to every institution in which that client has business, but also framing each argument in the strongest terms of the law that greatly benefit the client while remaining faithful to the facts and to the law itself. Zealous advocacy is a requirement of the oaths required by attorneys admitted to the success of the adversary system of justice. Disruptive, disrespectful, degrading, or any disparaging rhetoric is never an inclusion of zealous advocacy, and the use of such crosses the line from acceptable, forceful advocacy into unethical conduct. The Bouvier Law Library. Again, 2012 edition. Y'all, we're continuing on. But you know what? 31 pages in. We're going to finish this one tonight. Attorney misconduct is a failure of an attorney to comport with the rules and accepted professional customs of the bar, and includes any act or omission of duty by an attorney that fails to perform appropriately the office of an attorney as an officer to the court, as a counselor and fiduciary of a client, or as a member of the legal profession. Y'all, one of my favorite words to say is fiduciary. Truly. The scope of attorney misconduct reaches also to conduct of attorneys that is harmful to the appropriate reliance of the citizenry upon the law and legal profession. Attorney misconduct includes actions or omissions that enable others to cause harm, not just harm caused directly by the attorney, and not all misconduct is subject to remedy or to sanctions, although a variety of forms of each exist. Misconduct may always be the basis for a client to remove an attorney from their duty of representation, as is any other cause for the client's loss of trust and confidence in a lawyer, and the attorney's demeanor to determine whether a party's substantial rights were affected. Based on repeated or persistent objected to misconduct, the district court shall factor into its analysis that the notion by engaging in continued misconduct, the offending attorney has accepted the risk that the client's case may be influenced by said misconduct. Therefore, the district court shall give great weight to the fact that single instances of improper conduct that could have been cured by objection and admonishment might not be curable when that improper conduct is repeated or persistent. Bouvier Law Dictionary, 2012 edition. Duress, an unlawful threat that limits the person's independence of judgment or action and is any improper threat or condition, such as coercion, that limits a person's ability to think or act independently, and the presence of destroys the independence required of the party subject to. Yet. No, I'm kidding. In order to constitute a voluntary consent, it must delete extra words or duplicate words. All right. Well, that's definitely me for sure. Yes, accurate. I literally just moved into the mic and talked to Sarah through the camera, since I'm a YouTuber and she loves us. Must clearly appear that the search was voluntarily permitted or expressly invited and agreed to by the person whose right is involved. In addition, such person must be cognizant of their rights in the premises. The consent must not be contaminated by any duress or coercion, and the government has the burden of proof. Habeas corpus. Great writ. A review of the lawfulness of any person's custody or restraint by a government official. It is a process of judicial review of any person's detention, whether by formal custody, incarceration, or continuing restraint by an official or agent of the government of a state or the federal government. The right of review of custody by habeas corpus is a fundamental constitutional right. It is a bulwark of individual liberty being used to free people by courts without legal authority or without having complied with the requirements of law. Habeas corpus is protected in the U.S. Constitution from interference. I think it's at this point where everybody should say, land the plane, Sarah. A defendant who has been confined for 30 days after their arrest without trial shall be allowed a preliminary hearing upon application. Informal consent. Consent given with the appropriate knowledge after the person giving consent has learned all of the information that would be reasonably required for the basis of a reasonable decision. In many instances, for an institution or professional to prove that the decision maker was sufficiently informed over a matter to give informed consent, the institution or professional will provide the information requisite to making such a decision in an informed way, but the provision of this information is not a legal requirement to receive informed consent unless a custom, statute, or regulation requires it. An attorney or other professional has an obligation to provide any person with adequate information and explanation of a proposed course of action and its alternatives for the person to know of the material risks of each before consenting. By definition, professionals and fiduciaries, have similar obligations to their clients and to these with a reasonable right to rely on their information or advice before consenting. The lawyer or other professional shall, 1, promptly inform the client of any decision or circumstance with respect to which the client's informed consent as defined in Rule 1.0e is required by these rules. 2, reasonably consult with client about the means by which the client's objectives are to be accomplished. 3, keep the client informed about the status of the matter. 4, promptly comply with reasonable requests for information. 5, consult with the client about any relevant limitation on the lawyer's or other professional's conduct when they know that the client expects assistance not permitted by the rules of professional conduct or other law. Good grief. Do 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 do. We're still going through stuff. Yes, I am indeed skipping. Because why? Wait, hold on. That's funny. Yeah, long-winded she is. Excited utterance. Spontaneous declaration or spontaneous exclamation. An unthinking statement made at a moment of great surprise. Oh, fuck! And stress. Oh, fuck. An excited utterance is a statement made during or immediately after the declarant is surprised by a startling event or condition while the declarant is under the stress of excitement caused by the event or condition. In other words, if you're zipped up in a suitcase and then all of a sudden it's just, what the I don't want to do this any. That would be an excited utterance. What are we? I know I can't really rotate this. I might be able to. I don't know what we're looking at here. I would like to know. I would like to know. Night, Jasper. Meh. Oh, cool. I can. Hold on. Give me 1 second. Get back to it. Rotate. You go away for a second. That's weird. I'll zoom in. I don't really understand what's going on here. Oh, publicity, exploitation, and saturation is what she said. What does that mean? Like that? Those are the hits. That's where she's from. That's where she's being pushed from. I just want to say this star over here is not me. That's all. Let's see. Oh, we've got the world too. Look at that. She's worldwide. Yikes. Let's go back into this. We're going to go back to the other screen that was much better and larger. There you go. Publicity. Oh, here you go. She's going to explain the map. Publicity, exploitation, and saturation. United States map, page 1. To date, each star is a state where I've received correspondence via mail or message regarding my current criminal case. World map, page 2. To date, each star is a continent where I have received correspondence via mail or message regarding my criminal case. The number grows daily. Most all letters and messages are available for review and understanding of the impact of my case details being made readily available on the global internet, creating wrongful ignorance, hate, and massive prejudgment before my trial. I, the defendant in my case, have not yet ongoing 5 years fully reviewed or even seen all of my case details. Everyone in the world has already had the opportunity to do so themselves. The continuation of the obvious exploitation sounds like the beginning of like a Schoolhouse Rock. Conjunction, junction, continuation of the obvious exploitation. That doesn't fit. It doesn't matter. Allows the world to keep pressing their incorrect, presumed unfair theories, ideas, accusations, forcibly insinuating I committed criminal acts. My present attorney said it is not necessary to receive a court order. I've been trying to obtain to download my case information to apply from the OCCD tablets. My former attorneys are withholding some of my case contents I have supplied to them, and which has been deemed lost. Many other items have been returned, not to myself, but to the next attorney, and which have been unable to be located to date. I am missing innumerable case items, which I continuously request to be returned or obtained without success. Invasion of privacy. Supreme Court wrongful conduct. Appropriation, the unlawful use of a person's name or likeness to obtain some benefit. 2. Intrusion, physically or electronically intruding into one's private quarters. Phrasing. 3. Public disclosure of private facts, the dissemination of truthful private information which a reasonable person would find objectionable. 4. False light in the public eye, publication of facts which place a person in a false light, even though the facts themselves may not be defamatory. Ma'am, that video, pretty bad. Defame, to injure or destroy the reputation of by libel or slander. Anything is defamatory if, quote, it has the tendency to render the party about whom it is published contemptible or ridiculous in public estimation, or expose them to public hatred or contempt, or hinder virtuous men from associating with him. What? What is that part of the definition about? Jesus. An opinion can be actionable, quote, if it implies the allegation of undisclosed defamatory facts as the basis for the opinion. Publicizing some matter to create a false and harmful impression. False light, ma'am, this is not a false light. It's a spotlight, and it's right on your face. And I'm sorry you don't like it, but here we are. False light is both a theory of invasion of privacy and, in some jurisdictions, an independent cause of action, arising when a person, 1, gives publicity to a matter concerning another person that places the victim before the public in a false light. 2, that would be highly offensive to a reasonable person. 3, when the person or persons giving or creating the publicity either had knowledge of the false light that would result or acted in reckless disregard of the falsity of the publicized matter or the false light in which the other would be placed. You know what I think? I think this letter was written because for some reason the prison went on lockdown and she just had more time. In order to state a claim for false light invasion of privacy, a person need not prove that they have been defamed. Rather, it is enough that they are given unreasonable and highly objectionable publicity that attributes to their character, conduct, or beliefs that are false, and so is placed before public in a false position. The line is drawn when the publicity ceases to be the giving of information to which the public is entitled and becomes a morbid and sensational prying. Okay, is that where you stop? Sensational prying. We got underlined words, y'all. We got a thesaurus. A thesaurus. We're almost done. Publicity, exploitation, and saturation. My personal, individual criminal case is being advantageously exploited and abused from all of my significant life-saving, suppressible case details. Evidence, proof being illegally obtained by coercion, trickery, duress, confusion, roll for trickery, and without my permission, in any form, written or verbal, to anyone, then broadcasted, distributed, hand-delivered to the entire planet, states, countries, continents. That does make up the entire planet, containing all of my potential jurors, causing ma'am, you don't have jurors in Egypt. Irreparable, erroneous, I love that word, falseness, greatly tainting choice, my jury pool altogether by forcibly attributing heavily influenced, incorrect, inappropriate motives, theories, ideas. This obvious exploitation and invasion of my privacy is creating unnecessary, unlawful oppression, depleting all of my entitled opportunities to be given a fair, proper, successful conclusion of my case. However, it did give me a lot of street cred in the prison. It's not there. A misprejudgment has already been made unfairly against me from the undeniable violations of my constitutional rights and due process of law as a result of my entire case and personal life being publicized globally before my rightful trial, which lawfully, ethically should be without disadvantage and free from all partiality, deceitfulness, and dishonesty made from said evident exploitation. Definitions collected from. Ma'am, we've gone over this. We've gone over the definitions. We've done this. I love the fact that she had to define taint. Is there anything in here that's interesting? Prejudgment. Ma'am, this is ridiculous. Wow, man, she really had a lot of time on her hands. We're still doing it. Oh, here we go. Freedom of Information Act. 9 categories of government except from freedom of information. All right, well, the 9 categories of government information exempt from Freedom of Information Act are, and she just reads number 7. Law enforcement records, if their production could reasonably be expected to interfere with enforcement proceedings to deprive a person of a right to a fair trial or an impartial adjudication, to constitute an unwarranted invasion of personal privacy, to endanger the life or physical safety of an individual. And scene. Whew! Wowzers. The fact that the next one's only 5 pages makes me happy. Wow. Sarah decided really to take advantage of the time she's got. Some find jailhouse Jesus, and some decide to teach law lessons to judges. Can't imagine that went well. But at this point, it's got to be an eye roll, right? Just so you all know, Women on Death Row. I have not watched her interview. No. That might be something that we do if there's time next week. So could be interesting. Little old school night court for the transcript. So Women on Death Row is Tuesdays and Fridays now. It is not going to switch back and forth Thursday, Fridays. It's just too much. It's too complicated. So it's going to be every Tuesday and Friday at 9. Actually, that's not true. Sorry. 7 o'clock. Of course, Dearest Mother's Darkest Secret is coming soon. And so that'll go out early to members. This Friday, we got the second. Well, it's the multiple. It's higher installment, but it's a second installment of the brand new Hey Ho Show with Llama, Rudy, and myself. And I've taken a look at the outline, and I've taken a look at some of the subjects and stuff that we're talking about, and it's going to be a doozy. So if you're on the replay crew, check us out on Friday. It'll be Friday at 9 o'clock Eastern, and we will see you then. I appreciate all of you for hanging out with me tonight. This stuff's really interesting to me. I hope it's interesting to you all as well. It just the mind. It just boggles the mind. So listen, you all have a wonderful, wonderful night. I will see you all live on Friday, 9 o'clock. Hey Ho Show. Thank you for tuning in. A lot of stuff's coming. You're going to start seeing some cool stuff. We just popped up like a little teaser trailer on our community page / new video. There are changes that are coming to the channel. Get ready. So yeah, thank you so much. I appreciate it. Please take care of yourself, your friends, your family, and your community. Do not let anybody dull that sparkle. And shine on, you crazy diamonds. Shine on. You should be able to shine for how much pressure was on for tonight with the letter. Jeez Louise. We'll see you all on Friday live. Bye, everybody.